When a client calls us and walks the door, they can and should expect everything from the beginning to the end of the case being having direct access to the attorney that's going to initially evaluate it all the way through resolution. So what initially happens is whether the client wants us to meet with them at a convenient location or one of our several offices in person, or certainly over the new world of Zoom, we're happy to do that. And from that moment on, they get direct access to the attorney as we review medical records, we order them on the client's behalf, we incur all of the expenses. If it involves a death case, we will pay for probate and make sure that everything is aligned there to obtain and review the records. That takes a little bit of time, but we are in direct communication from then on with the client. Once the review of the case is completed, we consult a medical expert or two or three, whichever we feel is needed for the type of case that it is. And then that expert has to support the case before we can ever file it in the court of law. Once we're through that next step, depending on the time frame of it, there's 3 years to file a case from when you knew or should have known of the medical negligence, whether it's the wrongful death or it's a failure to diagnose or it's a birth injury. Depending on, again, the date or knew or should have known, we have 3 years to file. But meanwhile, if it's within 6 months of filing, there's something called the 60L statute, and that's where we send a notice out to the potential defendants that we're going to be naming in the court. Once that time frame is over, we go ahead and file it in suit, and then it's sort of a waiting game for the clients. And again, this is where we really try to strive and focus on direct access, because this can take anywhere from 3 to 4 years, and it's just a really long haul. So there's different types of questions that is exchanged back and forth between the defendants and our office, and we personally will sit down with the clients or on the phone and help them answer that so they're comfortable, as well as at any point in time when their deposition is taken, we're there and we meet with them ahead of time and prepare them ahead of time, and we sit there the entire time to make sure that they feel comfortable, they aren't bullied or ganged up on, and we make it as peaceful as possible given the potential catastrophic nature of why they're there and why they've retained us. Over the course of that time, at the end of 3 years, we hope that we can resolve the case either through mediation or direct settlement. And if that is not an option, or we advise against the settlement offer, because we do not want a client to just take anything under the sun. We want to make sure that they're fairly compensated and they're appropriately taken care of, especially if they're still alive and have future needs that need to be met. Then we will go forward and prosecute the case at trial with a jury all the way through the end. And the client, again, will have immediate direct access. We will be there at trial with them. They will sit there and watch. They will have their day in court, which many often want to. They will be able to directly view the defendants and hear the defendants' answers and see what a jury has to say at the end. So really, our boutique law firm is really focused on making sure the client has a direct understanding and direct access from the beginning of the case all the way through the end.